The Committee of the Whole is reconvened. We left off last with Senator Bloss. Senator Bloss, you're recognized.
Thank you, Mr. Chair, and again, thank you to the panelists for being able to answer some questions. Just like I have a couple. Ms. Renee, you yesterday had spoken about the technical amendments, if you will, that's done in the bills and stuff. Recognizing that in the discussion of the language that was placed in this bill, there was some concern about it being technical in nature. Am I correct?
Yes, that was inadvertently placed there.
Okay. Is there a process that you have now where all those areas that were supposed to be technical in nature, whether or not they were technical, but you noted that it can be passed on to legal counsel so that they too can have a set of eyes to see as to whether or not it does conform to form, or whether or not that should be considered?
Yes, thank you. We have a what's called a floor ledger that we provide. This is accompanying the working bill, and the only when we provide this ledger, it's accompanied by the passed only floor amendments. On the ledger, it would also indicate failed, withdrawn, in the case of 130, out of order. It will also indicate a technical, and usually when it's a technical, it's not considered to be an amendment, but a motion to allow legal to make those technicals, but it is with the ledger, indicated in the ledger and accompanying it with the ledger.
Okay. So then if it is and I've noticed that there's more so in this legislature than I've been in others, that there's this clause that's oftentimes used that we're going to allow legal counsel to make the technical amendments. Do you believe, or would you feel that, and maybe this is a question for legal counsel, that then before that's done, even if they ask you to do it, that there be a process now that when you are done doing that, it goes back to the proffer of that amendment so that it does reflect the true intent of what that proffer of the amendment provides?
Yes.
Okay, I appreciate that. Now, last question. Do I, as the authority, as Senator Frank Bloss, do I have the ability or the authority or the responsibility of sending a bill to the governor on behalf of the legislature?
No, Senator.
Does Senator Pito have that ability?
No, Senator.
Senator Joanne, does she have that ability?
No, Senator.
Do you have that ability?
No, I do not, Senator.
Madam Legal Counsel, do you have that ability?
No, Senator.
Who ultimately has that responsibility and ability to do that?
Just to clarify the question, is it the physical ability to transmit, or are we talking about the authority,
The authority.
or the certification, or?
We finally say this is representative of what the body has deliberated and worked on, and so therefore we're delivering it to you. It is now in your hands. In the case of the bill to the governor, which hands does it go to and is finally responsible for?
Okay, Senator, my understanding of the question is the physical being to take.
Not just the fiscal, because it could be done physically,
Okay.
but
So procedurally, the bill or the passage of the bill is, we produce what's called the certification page. And we take the certification page, which is certified by the Speaker and attested by Legislative Secretary. We circulate that certification page accompanying the bill to Speaker's office, and after that, Legislative Secretary.
but nothing leaves this body without the Speaker's approval?
The certification, yes, that's how procedurally it's transmitted. Then from there, we will make arrangement with the,
So although it could be within all of our hands, whether it be to proofread or see whether or not our amendments are intact or whatnot, the final authority, the final person, the only individual that can then move that bill from this body to the executive branch is the Speaker.
the bill would have to be accompanied by the certification.
Sure,
page. Yes.
sure. But if it doesn't get her,
Yes.
if
and-
it doesn't get that person's signature or blessing, it doesn't go. I can't do it, right?
No, you can't.
Okay. Thank you. Thank you, Mr. Chair.
Thank you, Senator Bloss. We are now on the final row of the second round. Senator Torres, you're recognized.
Thank you, Mr. Chair. Yesterday, Renee, when I was speaking, I had talked about timelines. And I want to go back and just get more clarification on that. Because you went through the whole litany of what exactly happened, what transpired, and where you believe the error in including the language was committed, at what point in the timeline. But I think the overarching concern here for many of us, or should be for many of us, is the timeline that you were provided to engross the bills. Because as I had mentioned yesterday, I believe that in any case where you're pushed against a wall, the risk of committing errors is greater when you're not afforded what is customarily the time that you're afforded to perform your job. And I had also expressed confidence that I had seen in the job that you and your staff and our legal counsel and her staff has committed to this body over the years. We also discussed that there may be a modification to your process where you will write a memo to the body requesting additional time if necessary. And I think that that's a great way for you to assert what would be a reasonable climate and environment for you to perform your job. So I totally agree with that remedy. I want to go back to the timeline though, and if you can please tell me, what are you normally afforded between when we recess after we vote on the third voting file, up until the time that we come in again to actually vote on the bills and resolutions? What is that timeline usually? Is it 24 hours? Is it 48 hours? Is it more?
I was tracking time with the previous sessions. 48 hours, 24 hours is like a common, what I would say that we've had for the engrossed process. Mm-hmm. It's a give or take depending on the discussion and how much time we are given. Usually while if we are notified that we are going to be preparing for voting, then the discussion, I will consult with legal, and then we will try to figure out how much time we would need. And that's also to include the items or the measures or the items that have been discussed. And then sometimes, in instance, possibility of entertaining and adding something on session agenda or other items. So the timing just, it varies.
Okay, but I know from experience here that as a senator, we generally recess and re-adjourn in a couple days, usually, especially when the agenda is loaded and there are many bills and many nominations. That's my experience, is we generally know that when we recess, we're not going to vote for about 2 days, and it could be shortened. In this case, though, when we voted on Bill 130, from the time we recessed to the time we voted, what was that time frame? Was it 1 day? Was it 2 days? Between when we recessed and when we voted that evening? How much time was it between the recess and the reconvening?
For 1:30, as far as I can recall, on Friday, that when we were when the discussion was done, we did, prior to the discussion of 1:30, we did entertain voting on 2 measures. So after we were informed that we will be voting on Monday, or to prepare engrossment so that we can possible voting on Monday at 5 p.m., legal counsel and I came in over the weekend and tried to engross as much as we can. Then we were still in discussion. We were in a committee of the whole with 2. We were on discussion on 1 measure and pending another. So I wouldn't give a estimate time. I know that that day that we came in and worked specifically on 1:30, it was a back and forth effort.
So you were here on Monday, you were working on Monday, the body was meeting on Monday, and then the body recessed and voted Monday evening.
That's
So
correct.
it wasn't a day that you had to put everything aside, step out of this session hall, and work on engrossing bills. That's what I'm trying to get at, is that if I were to expect something from you, I would expect that I should give you the environment to do your job the way that you would need to, not to do your job simultaneous with engrossing a bill simultaneously with sitting in a session and monitoring everything and recording everything that as the session is going on. So that's what I'm trying to establish here, is that you, in fact, were doing many things at once on that Monday that we were supposed, that you would ordinarily be in your office just engrossing bills. You were actually on the floor. All 3 of you were on the floor that Monday doing, with the sessions, in addition to having to prep for engrossing and for the voting that evening. So I just wanted to make that point because I think that's a critical point. And correct me if I'm wrong, but I believe based on the discussion, and I wasn't present, I was not here for that session. I was absent in that session, but from what I understand, you were working all through Monday, recessed probably for lunch, is that correct?
Yes, that's correct.
And then voted that evening.
Yes.
So where you're normally given a day or 2 days separate from session, you were actually here and you only had the luxury, or you were afforded only a few hours on your own to engross the bills. I mean, technically, the time away from session was only a few hours. Is that correct?
That's correct.
Yeah. So I believe you were given very, very little time that would have possibly given you the opportunity to catch errors if there were in fact errors. And I truly believe that if you were given sufficient time as you normally would have, you would have caught these errors. I believe you would have. Is that a fair assessment?
Yes, thank you, Senator. Yes, thank you.
Okay, thank you, Mr. Chair. I just want to make that point about the time.
Thank you, Senator Torres. Senator Dueñas.
Mr. Chairman. And I want to first start by thanking you and the body for agreeing to take this time to go through this process. I want to thank the clerk. I want to thank legal counsel for their forthright answers. And I think this process has been very well conducted. I think everybody has been meaningful and sincere in their efforts. Mr. Chairman, I only have a couple of comments. I don't have any more questions, but my comments are on the going forward basis. Yesterday, a colleague of ours, rightly so, in terms of their own concern, discussed the issue of the possibility of additional members from the fiscal team to be on the panel. I think you handled it well. I think that if we look at the bill clearly states, first and foremost, 3 fundamental things. One is the governor is responsible to send us a plan. There is a current public law that we're going to be repealing if we pass this bill. But that public law is in place, and I fully expect that the governor, and the lieutenant governor has intimated this, that they are in the process of preparing a plan. That plan is probably only 17 or 20 days away now because of the process that we've been engaged in. Mr. Chairman, on the last page of this bill, there are 2 sections which clearly outline the funding source for this plan. There are 2 sections there. First of all, there's establishment of an account. And second of all, there is authorization for the governor to find the resources outside of that under her purview and control. There is no impediment for this bill going forward. There is no impediment for the anticipated $10+ million to be paid for those survivors or those survivors who went home to Jesus prior to being able to apply for this benefit, for this justice, having met their fate to go to their Maker based on an arbitrary date established. Whether we like it, whether we don't like it, that's what happened. That's the law. We're establishing this local program, Mr. Chairman, in my humblest of opinions, that has every mechanism capable of executing this process if we are to vote on this bill, as I've reviewed it now, as it should have been voted on, technically, when we voted. My closing statement, Mr. Chairman, is I'm going to object to, and I think that we should not proffer any amendments on this bill as we are in the Committee of the Whole. This is not the time nor the place to get up on a stage and try to do something again in this bill when it is a bill that was fully debated on this floor. We are making the right decision, the technical decision. I think my good friend, our minority whip, Senator Frank Blas Jr., alluded to this during his testimony as well, when we were asking questions about why we should bring the team back down and do all this process as though we were debating the bill in its original form. We're not doing that, Mr. Chairman. So I'm going to register and be very clear, and I hope the body will follow through on any objection that I will proffer to any amendment on this bill. We should do our due diligence, do what we were supposed to do when this bill was in the voting file. Vote for it in its form, and now a repealer, because we have to repeal a current public law and move on with the business of the day. We have members who have introduced the bill. That will be fully debated. That's exactly what we were trying to do when you or your chairman, the primary chairman, ruled this amendment materially different, non-germane, and out of order. That's my closing statement, Mr. Chairman. I hope this body will move forward on the process, vote on this bill, and get it done so that our people can be relieved, that those who are eligible for this can move forward, and a plan will come to us, and we'll deliberate that plan. Jesus Masi, Mr. Chairman.
Thank you, Senator Duenas. Senator Moylan.
Thank you, Mr. Chairman. Thank you to my colleague for those comments. I do agree. I also like to make just a few more comments. I noticed that we are discussing, or was introduced on this floor, of the 217 substituted version as substituted on the floor, which we accepted. Yet when I go to the legislature website, I see 217 as originally introduced by the speaker, which was identical to 130. But now we're looking at 217 as substituted on the floor, but yet on the legislature website, it still has the original 217, not the substituted version, but the identical version. I understand there's some procedures of why that is so, but I appreciate if the clerk can just explain the situation, please.
Thank you, Senator. So the website provides information of all official documentation received, correspondences received, introductions. Now that we are in session, the body had accepted a substituted version of the bill. Therefore, the website doesn't accommodate real-time discussion during session, and it's procedural, though it does not deter any of the members to request that it is placed on the website for a public view. Though my understanding is that the Google Drive is available to PH notice, and that also filters out to, if I'm not mistaken, certain departments, agencies, media outlets, not just the members or staff. But in the event that a member would like it available on the website, then a request to Committee on Rules and Speaker may be so, and that we can forward the substituted version for public view.
Thank you. It's probably something I can pursue later, Mr. Chair. One other question I noticed between the Public Law 3659, there were actually a couple of amendments we did to Bill 130. One, of course, which we're trying to strike through, but the other regarded adjudication committee. Now, in the 217, as introduced on the website, it does not show that, but on the 217 as substituted on the floor, it does. And on the Public Law page 3659, Public Law 3659, page 5, line 4, it makes, I guess this could possibly be, it refers to descendants. And I'm just wondering if we can confirm that when the author of this amendment submitted it, this is how it was read, or this is how it was transposed to the engrossed version of Public Law 3659. So that would be on page 5, line 4 of Public Law 3659.
Could you, I'm sorry, Senator, could you explain that, restate the question again?
Yes. So my question is, I wish to confirm, when the amendment was submitted, did the submitted version, is that verbatim as what it states on Public Law 3659, page 5, the complete sentence, it goes from line 3 to line 6. Yeah, and the main reason is the word descendants is used in the Public Law, and then when I compare it to the substitute version of 217 as submitted on the floor, when I find that section in the substitute version, instead of descendants, we now use the word decedents. And the definitions of the words are, there is a difference. So, Mr. Chair, for the clerk, it's just confirming that this is how it was submitted in the public law based on how the amendment was written and voted on the floor. Thank you.
Thank you, Senator. So I have the passed floor amendment in front of me, and it was, the spelling and the word itself was as submitted on Bill number 130, so that it maintained what was submitted through the floor amendment.
So if I just read half of that sentence, it goes, or survivors of compensable Guam descendants is correct. It was transferred correctly to the public law 3659 as we voted to approve that.
Yes, that's correct.
Okay. Mr. Chair, maybe afterwards, then I would, or probably now, how does it go from descendants to the new wording of and survivors of compensable Guam decedents? For my colleagues, if we're referring to the substitute version, that will be on page 5, starting from line 10. The specific line is line 11. Page 5, the substitute, as substitute on the floor.
Senator Moylan, you're referencing the substitute bill that we are discussing now, right?
Yes, Mr. Chair.
Would you like to proffer that question to the author of the substitute bill?
I'll be happy to. If this is the right time, or do we conclude a committee as a whole first? Your call, Mr. Chair.
No, you can ask the author of the substitute for the
Okay.
reason for that language.
Sure.
Point of inquiry.
Sure.
Thank you, Mr. Chair. Is this just a spelling error?
All right.
According to the clerks, it's not a spelling error.
Okay. Okay, thank you.
Okay. Thank you, Mr. Chair. Thank you, colleagues. So I would like to then ask to the bill sponsor from Public Law 3659. If I read it, it says on page 5 of the public law, starting from line 3, the adjudication committee shall adjudicate all applications submitted by compensable Guam victims or survivors of compensable Guam decedents. Okay. And if you compare that with our substitute version of 217 as substituted on the floor, page 5, the adjudication committee shall adjudicate all applications submitted by compensable Guam victims and survivors of compensable Guam decedents. So I'd like to know from the author, these are two different meanings, two different words, and how do we conclude to change it in the substitute version when it was submitted and confirmed that is in the public law version of 3659? Mr. Chair.
So, again, I'd like to ask you if your question is for the sponsor of the measure.
Yes, Mr. Chair. Kindly request the sponsor to reply.
If so, can I ask you to make that question in the final round after we've dismissed this panel?
Absolutely. Thank you, Mr. Chair.
Okay. Thank you, Senator Moylan. Is there anything else you'd like to ask of this panel?
I'm good. Thank you.
Thank you, Senator Moylan.
Point of information, Mr. Chair.
Yes.
I think the panel would be able to provide information on that because if it was in the track changes, they would be able to address that.
My apologies, Senator. We are prohibited from discussing matters relating to representation of the legislature and giving legal advice or legal interpretations of this change in this forum. However, if we take a recess, I'd be happy to explain that change.
Okay, I'll call for a moment's recess.
Can everyone hear me?
Okay, we are back from recess. Senator Titlegy?
Thank you, Mr. Chair. Mr. Chair, I'd like to take the time to thank first for the speaker to actually ensure that the language in this substitute version, any mistakes that were made prior, we obviously found one huge one, but there were other corrections that needed to be done and to clean up the language in the bill. So I'd like to thank the speaker for proofreading again and again to ensure that those come in, and the assistance of legal. Thank you so much.
Thank you, Senator Titlegy. Okay, that is the end of round 2. We are going to recess, dismiss the panel, and then begin round 3. Moments recess. Okay, we are back from recess. This is the third and final round. This round is for amendments and any closing statements that any members would like to make. We will begin now with Senator Terlahi. You are recognized. Senator Bloss, you are recognized.
Thank you, Mr. Chair. Mr. Chair, I think as from the first 2 rounds, I think the body has received the information sufficient enough to know how we got here and where we're going. So therefore, I don't see it necessary to be able to append the statement made by our colleague on behalf of the sponsor of the legislation to be appended into the bill, into the report of the bill. So I move that, well, it's not, we didn't even move this, so if we can just, 10-second recess so I can talk to the clerk.
Moments recess.
We didn't append this, right? No need for a motion then.
Okay, we're back from recess. Senator Bloss, you're recognized.
There's no need for a motion, Mr. Chair,
Okay.
because it's not appended. Okay? Thank you very much.
Thank you, Senator Bloss. Senator Titlegy.
Thank you, Mr. Chair. And again, I'd like to thank the staff for providing the information, answering our questions. Appreciate the work and to assure us that these mistakes will not happen again. I mean, you can't always guarantee. Mistakes are made. Nobody's perfect. But at least now we'll put better measures in place. And I just for the record, Mr. Chair, it was discussed earlier about particular language in the bill, descendants versus, on October 25th, the speaker sent us an email explaining all the changes in this substituted version on October 29th at 11:55 a.m., and she spells out clearly all the changes that were made technically into the substituted version. and explains these areas that Senator from Tumon mentioned. So again, I'd like to thank the speaker for this substituted version, cleaning it up and ensuring that the intention of this bill is true to form. It's what we anticipated and expected when we voted on, Bill 130. Mr. Chair, during that time, I was one of those who supported that amendment that was mistakenly placed into the bill. I think there was only 4 of us in this body that supported something like this. But where we are today is to ensure what was passed is corrected, which we are doing today. And whatever comes up in the future, I hope that this body realizes that there's so much more to think about before moving forward on any other consideration. But to never forget those who passed away before the deadline on December 2016, and to remember them, even if it means having to acknowledge them to their family members who are still alive today. Again, I'd like to thank the speaker for stepping up and being the one to introduce the substituted version when nobody offered. Thank you, Mr. Chair.
Thank you, Senator Taidegui. Senator Torres. Senator Dueñas. Senator Moylan.
Thank you, Mr. Chair. Since the passage of 3659, our office and probably many of my colleagues' office have been probably getting calls from constituents requesting serious consideration for descendants, not decedents, but descendants, to be included in the local plan. And what it was confirmed today that the version of the bill, which originally our speaker has showed to be identical to 130, is what's showing on the website. But yet, over the weekend, directed to the senators, which gave us time to review it, we were able to see a substitute version that made these changes that the public is slowly beginning to understand. I would probably be much more comfortable when we make these changes for the public to understand and to have a public hearing about it before rushing into something once again that seems to you can find it on a certain website or on a drive, but it should be plastered at every place we can, and I'll make that request to the speaker to include it on the website, so how we normally find bills can be discussed. It's a big change from Public Law 3659 and what we're doing here on the substitute version. And if we're talking about clarity, and we're talking about transparency, and we're talking about how important words are in definitions in Webster's dictionary, so the folks can understand, I feel a little hesitant on seeing what we can do with this bill. I appreciate the efforts that we're making, but I really think a public hearing will be the right thing to do. So I thank you, Mr. Chairman.
Thank you, Senator Moylan. Senator Ada.
Thank you, Mr. Chair. I'd just like to once again thank the clerk's office, and also the Legal Bureau for coming down to answering and actually taking us step by step on the process of how the procedures of what we do to pass legislation and how it gets transmitted. At no time was this a witch hunt for the clerks or the Legal Bureau. This was actually just to give the public the assurance that when the process of passing legislation is going to be adhered to, and what we're doing in the future to ensure that this does not happen again. So again, I'd like to thank the clerk's office and the legal bureau, and I look forward to moving legislation forward again and getting back into our regular session so that we can continue with the work for the people of Guam. Thank you, Mr. Chair.
Thank you, Senator Atta. Senator Brown.
Thank you very much, Mr. Chairman. I am pleased we finally were able to address the issues and the questions that we had concerning the process that actually led to the error that was included in the language in the bill that was forwarded to the governor and was signed into law. I think that was very important that we outline that process, find out how the error occurred, and certainly what we need to do moving forward to ensure that this sort of thing doesn't happen again. I'm very hopeful that our key staff that are actually in charge of engrossing the bill and preparing it to be transmitted to the governor in the future will make those extra steps and ensure that collectively, particularly our clerk, is going to ensure the overall actions that occur with regards to the bill are accounted for at her level. And that if adequate time is needed, as has been raised by the staff at the legislature, that they will voice those concerns. Because as we mentioned, I mean, most of us here don't determine the clock or the schedule as to when we vote. We're simply told when to come. And, we assume things are in order. And that's an expectation certainly we should have. It's an expectation the public should have in terms of our performance. We're a $7 million legislature. I think we should expect that. But overall, the more important issue is correcting the error so that we can move forward with compensating our survivors that, after 78 years, they have walked such a long walk and waited such a long time to receive recognition. We often talk about money, but gosh, to me, money's very fleeting. It's nice to have, but, it can slip through your fingers so quickly. So I don't think this is about money with regards to addressing this issue primarily for those survivors, because we know there's so many of our family members, those of us that are descendants of what we do call the greatest generation, and deservingly so, that we're not here to ever experience this recognition, that we will never, no matter what we do, no matter what action this legislature takes moving forward, we're never going to be able to correct that for those that have died, and the majority of them have died. I think of all those that 33 years ago, when I was executive director of the War Reparations Commission, so many who came and filed their claims, and many of them who have since passed away, never receiving the opportunity to know that their suffering is being acknowledged by the U.S. government, which is ultimately the government that has taken on that responsibility from the government of Japan. So with that, Mr. Chairman, I have no further comment to make, and I'm hopeful that we can properly address this bill, have it engrossed, and send it to the governor to make the appropriate corrections, and that we can move forward with addressing compensation to our survivors, where time is so precious and they've waited so long. And we just need to move forward with regards to this bill. With that, thank you very much for the opportunity to comment.
Thank you, Senator Brown. Senator Shelton.
Thank you very much, Mr. Chair, and I want to thank everyone who spoke in today's panel and throughout the last couple of days for us to address this bill. We're once again here talking about the war claims and recalling our elders who have suffered immense injury, immense loss, and our families who have carried on this hurt and this legacy for many, many years. And they're right, the right of our survivors, the right of their families to be made whole. And we're aware of at least 700 of these claimants who have signed a petition to request an extension. These are descendants of survivors, at least 700 of them requesting for an extension of this application period, and for this application, these war claims to be available to even the descendants of survivors. It's because of them, it's because of these family members and these survivors that we still have, that we are encouraged and we continue to work to to make things right for them. And paying this long overdue debt is just one step in the process of helping to heal these very old wounds. And I think while we recognize the oversight that was in Public Law 3659, many of our Manumku, as was mentioned previously, have called our offices, have reached out to us with their support of the intent to pay all claims, regardless of the date of death, and asking us how they can plan accordingly for what to do next for their family members, perhaps for their parents or for their grandparents. And though this was an amendment that did not pass originally and was inadvertently left in the bill, it is now public law. And this was unfortunately a mistake, but it was a mistake that brought, I think, a moment of hope to so many, to finally see justice, to finally experience some type of closure. I think the question before us now is, what will we do with this hope that we've given so many of our people here in our community? Regardless of when they died, our survivors and their descendants deserve the recognition for their courage and for their sacrifice. And we have an opportunity to provide a path forward to fulfill the promises, the many, many promises we've made to these war survivors. I think there's no amount of money that can ever compensate them for the sufferings that they endured or bring them back. But it is the recognition and the very, very long overdue compensation that they are still waiting for. So we can't just turn this page and say to those we've given hope to that we're going to revert that. And so I can't wrap my mind around voting for this change in this bill today because we've opened this door now and given them this hope. And I ask our colleagues to join me and to move forward to help these families and these survivors who are still awaiting this recognition and this compensation. So do as masi, Mr. Chair.
Thank you, Senator Shelton. Senator Perez.
Thank you, Mr. Chair. I'd just like to provide some comments for myself and then the speaker so we can afford some time for her. I have closing comments for the speaker. If it's possible to have time for me and the speaker, because I'm going to provide my own comments.
Speaker is not present?
Yes, but if I can get time for both, I appreciate that.
No, I'm sorry.
Okay.
Time is allotted for members who are present, so you may choose to
Okay,
read
so
the speakers
if you
or
can
your
just
own.
stop, was it the clock stopped? Can we restart the time then?
Go ahead and start it at 5. Go ahead.
Okay.
You may proceed.
So I see it's very important to participate in this corrective action. You know, once the mistake was caught, it was important that we as a body stand up our procedures. And I think we all agreed to the gravity of the situation. But I think what we don't necessarily agree on is the source of the problem and, you know, the admission of the culpability of our body as a group. And, you know, there's this thing called redundancy, right, in a system. We see that in engineering, that if you have multiple protections, it could protect the whole system in place. And I think that any one of us could have caught it and said something. And that would have been the end of it. So I think, you know, as you can see in this whole exercise of the Committee of the Whole, you know, we saw how complicated or how complex this process is. And it's a very fast-paced process. Things happen very quickly. And, you know, we really have to be on top of these things. And more so that, you know, we don't have the proper resources for the clerks. If we had more of the technological supports, that will leave less, you know, less human error, involvement of human error. So I think that if we really truly want to prevent the recurrence of this problem, I think we have to look at it from a systemic view. I think also, when we're looking at this bill, I mean, the content of the bill is compensation for our war survivors. And I think, yes, we want to, remember them and compensate them. That's important. But I think more what we can do to honor them is to work harder for peace. And, look at what was the roots of World War II, right? I think those things are still very much at play today. Here we are living on an island with a huge military buildup, and we have no control over it. We have no control over what's happening, it seems like on our island, let alone definitely not outside our island. And, it's really about, how do we honor our ancestors? We need to speak out and speak up for the protection of our lands in a way that promotes peace. And I think this is one way we can do, our ancestors, more justice in this world. There's no amount of money that can compensate them. I think what we need to work harder for is looking at the roots of what brings war and work towards peace. Okay, so now I'd like to read a statement from the speaker. This substitute bill is about corrective action on Public Law 3659 and moving forward and getting justice for our war survivors and their families. This bill was my attempt to remedy the clerical error made during the last session on Bill 130 in the most expedient and non-controversial way possible. As stated previously, this bill, as substituted, is an exact mirror of the previous Bill 130 and includes all amendments that previously passed during deliberations on that measure last month with technical corrections. The change from descendants to decedents was made at the recommendation by our legal counsel and was done transparently. Passage of this bill will resolve the error, and I urge my colleagues to do that. Also, I have ensured that all sponsors were added in the same order. The new provision is the inclusion of a repeal of the law that was enacted in error. Bill 217 will open a local war claims program to cover those who survived beyond 2018 and missed the filing deadline. We are unsure how many people there are or how much that will cost. What it will not do, and I hope it is never said again, that passage of the previous bill or this bill closes the door on war claims, closes the door on the painful chapter in our history. Our parents' and grandparents' rights to recover from their suffering and harm imposed upon them during war occupation by one nation was waived by another. When the conquering nation's efforts to atone for that suffering were flawed by errors and conflicts and the distraction of a massive buildup and massive land takings. While I believe this bill is one step in attaining justice for Manumco, I do not think true justice will be had until we all account for all. So, thank you.
Thank you, Senator Perez. Does that conclude your comments? You have 11 seconds.
Yes, thank you.
Thank you, Senator Perez. Okay, this concludes the final round. We will take a brief recess. We are back from recess. Senator Perez, you're recognized.
Thank you, Mr. Chair. I move to rise from the Committee of the Whole with a recommendation that Bill number 217-36 LS as substituted on the floor, an act to repeal Public Law 3659 and Article 13.2 of Chapter 1, Division 1, Title 5 Guam Code annotated as enacted by the same, and to add a new Article 13.2 to Chapter 1, Division 1, Title 5 Guam Code annotated relative to establishing the Guam World War II Reconciliation Act of 2021 to compensate claims of the greatest generation of Guam for the atrocities suffered during World War II occupation of Guam, to be placed on the third reading file.
On that motion, are there any objections? Seeing none, motion carries.
Elahas Laturanguahan is back from recess. Senator Rajel, you are recognized.
Thank you, Madam Speaker. I wish to report back to the body after the deliberation of Bill number 217-36 LS as substituted on the floor, an act to repeal Public Law 36-59 and Article 13.2 of Chapter 1, Division 1, Title 5, Guam Code annotated as enacted by the same, and to add a new Article 13.2 to Chapter 1 of Division 1, Title 5, Guam Code annotated relative to establishing the Guam World War II Reconciliation Act of 2021 to compensate claims of the greatest generation of Guam for the atrocities suffered during the World War II occupation of Guam, and that the recommendation of the Committee of the Whole is to place substituted Bill number 217-36 LS on to the third reading file.
On the motion to place on the third reading file, hearing no objections, motion carries. The legislature will stand in recess until tomorrow at 3 p.m. for voting on Bill number 217-36 LS. Seduas Masi colleagues, see you tomorrow. We are in recess.